Welcome and thank you for joining us today. My name is Samantha Su and I am a committee member of the Malaysian chapter of the Honourable Society of Gray's Inn. I hope that everyone has settled down and is excited for today's webinar. Without further ado, I would like to invite the Master Treasurer of Gray's Inn, Ali Malek QC, to open today's webinar. Master Treasurer.
Thank you very much, Samantha. It's very good to speak to everyone today. My name is Ali Malek. On my left is Master Desmond Brown. And what we're going to do in this opening part of the discussion is really just explain what's been going on in the inn and to say something about the relationship with the Malaysian chapter of Gray's Inn, which is what this discussion is fundamentally about. As far as the inn is concerned, it's as you can imagine, it's all about COVID. We're eventually coming out of it, I think. It's been pretty tough. I mean, it was pretty tough for me when it all started, because I did the first hearing that was done virtually involving Kazakhstan, when no one really knew whether this was going to be possible. It was a big trial that my clients wanted to go ahead. The other side wanted to adjourn it until after COVID, but we did go ahead, and it was a financial list commercial court case before Mr. Justice Tiang. And we all did the case from our homes, and it's worked. And that's basically the start of where we are at the moment and going forward. For me, it was a rather awkward experience because I actually got COVID during the hearing. So I'm probably the first person to do a hearing at home, but also with COVID. But I wouldn't recommend it. So stay safe. I mean, as far as the inn is concerned, we are getting back. If you look, for example, what we've been doing recently, we had a couple of dinners last week. One was for the treasurers of the inn. There was another an event, a dinner in honour of Master Morris, who was an Attorney General and was 90, so it was to celebrate his birthday. We had a mixed messes session the weekend beforehand. We had a fireworks display with over 300 people in the garden. It's grand day tomorrow night. So the inn is slowly getting back to normal. What has changed? I think what has changed is the way that we communicate with each other. We're now doing things virtually. It means that we can have our governing body meetings, pension, which everybody can attend wherever they are. I think we're also probably becoming paperless, which is a good thing. I suppose if I was to say what concerns me most of all, it's the fact that a lot of people like working from home, and I can see what the advantages are of that. Avoiding the commutes, people with responsibilities for children. It's either to manage it, but there are serious costs in my view. I think it's particularly important for the younger members of the inn and barristers' chambers to be in contact with the more senior members, because that's essentially what it's all about, is by watching. I think that's very important. I'm also very concerned about well-being issues, because the division between work and home is diminishing. And I think the tendency is for people to work much longer hours, ironically. And that has, I believe, welfare issues. But I think overall the position is positive. I suppose the other thing connected with that, which makes me nervous, is the extent to which people will now think that they don't need to be working in chambers and therefore need less space. Because if you think about a barrister's room, what have we got traditionally? We've got lots and lots of files, and we've got lots and lots of books. Well, both have gone. I mean, if you look at my room, Desmond will confirm there are hardly any papers here at all, because it's all done on a computer. I still like books, but it may be that I'm old-fashioned. I've still got the books. But if you don't need books and you don't have papers and you're working at home, do you really need very much space? And that moves into things like hot desking. But for me, it's really important for everybody to come back as soon as possible. And I hope that the working from home doesn't mean that we lose out on all that collegiality and glue that is so important for everything we do. What would you find if you came to the inn now? How's it changed? Well, if you walked in from Holborn, the first thing that you would recognise is that we've got a road or street with a new name, Lady Halegate, believe it or not. So entirely appropriate, which reflects the respect and love that we have for Master Brenda Hale. You'd also find a new chambers, gatehouse chambers, that used to be called Hardwick chambers, but Hardwick was not a nice person, so they decided to change their name to gatehouse chambers. Now, if you were to come into the inn in September, next year, you'd also find something else, which is, you remember the CLE, the Council of Legal Education, where many of you probably did your exams. Well,
yes.
That's going to become a school. That's going to become a school for children between 7 and 11. I suppose it was slightly controversial, but everyone agreed to it in the end, and it's incredibly positive. We're going to have children that will be using our hall for lunch, and they're going to be, I believe it's going to be incredibly positive. It's really important for the inn to be within society. It's going to build our links with the City of London. And importantly, from a financial perspective, it means that one of our buildings is going to generate a lot of rent, which will go to pay for the scholarships. So overall, very, very positive. The only other thing I wanted to say, the last point I want to make, is the relationship between us and Malaysia, and particularly the Malaysian chapter. To me, this is really important. It's one of the points that has concerned me is that we've tended as an inn to sort of focus on education of aspiring barristers, which of course is what we're fundamentally about. But I also believe that we have some really important common values, which is not just the inn, but across all lawyers. And that consists of promoting the rule of law. It involves promoting access to justice. It's about promoting equality and diversity. And it's also about promoting the common law. And it's those things that I think that we should be working on. And we will do that. We're doing it already, but we can do it in a more formal structure. And I think with the advantage of Zoom and our ability to communicate, although we'd love to see you here in the inn, that may not be possible, it may be difficult, but what we can do is to communicate with each other, and we should be looking to putting on events, whether it's moots, debates, or lectures, or just general discussions, because we have so much to learn from each other. And that's what I think we should be looking at and discussing. That's all I want to say. I know Desmond wants to just say a hello to everybody, but thank you all very much.
Well, hello to everybody, and it's wonderful to see Tiang and Samantha again. I think I can say that they've become friends over the years, and my visits to Malaysia go back to the early days of international advocacy training in Kuala Lumpur. I remember vividly the dinner that we gave in the Majestic Hotel the year I was treasurer, and I have such fond memories of both the big cities in Malaysia, including Ipoh, but also going with my wife up to Sarawak and Sabah. I wouldn't want this occasion to go by without recording the debt that we all owe to Ajit Makur and Maidzuara Mohammed, the President and Secretary, respectively, of the Alumni Association. They have worked nobly over the years, and that Tiang should now step into their shoes is something that gives me the greatest possible pleasure. The loyalty that you've all demonstrated to the inn over the years is such that we in London must do everything we can to support you and the association. And above all, we must ensure that every young Malaysian who is called to the bar by the inn signs up with the alumni on returning home. On my visit to Kuala Lumpur in 2015, I discovered students who I had called as treasurer who had not yet joined the Alumni Association. We must catch them all. Anyway, it's a delight to be taking part this evening.
Thank you, Master Malek and Master Brown, for those kind opening words. I will now introduce our first speaker, Master Brenda Hale. I'm sure you know everything about her, but I'll still go through all her achievements, which are quite a lot. Master Hale was born in Leeds, West Riding of Yorkshire, and she then went on to, she later studied at Girton College, Cambridge, for which she had a starred first class for her BA, and she was also the top of her class. And after that, she obviously practiced law, and she was appointed a QC in 1989. She was made a Dame of the Commander of the British Empire, or DBE, in the Civil Division in 1994, upon appointment as a High Court judge. And she was sworn in as a member of Her Majesty's Most Honourable Privy Council in 1999, giving her the honorific title, the Right Honourable for Life. On the 12th of January 2004, she was given a life peerage upon being appointed as a Lord of Appeal in Ordinary, and she took the title of Baroness Hale of Richmond of Easby in the county of North Yorkshire. She sat in the House of Lords as a crossbencher. And of course, as everyone knows, she became the first woman to be the President of the Supreme Court of the United Kingdom. And there's a law building in the University of Salford that's named after her in 2008. And she's received an honorary fellowship from Bristol University, my alma mater, in July 2017, of which she was also the Chancellor of the university from 2004 to 2016. And without much ado, can I invite Master Hale to give a talk?
Well, thank you so very much for that very generous introduction. Of course, I have extremely fond memories of my only trip to Malaysia when in 2016 I came to deliver the Sultan Azlan Shah lecture. But it was a delightful occasion and it was wonderful to meet some of you then, and I hope that I'll be able to meet you again. You may not know that I am now the Sultan Azlan Shah Fellow at the Oxford Centre for Islamic Studies. So I am still associated with the great Sultan and jurist from your country. Anyway, I've been asked to talk about diversity and inclusion in the legal profession and the judiciary. Now, the notorious RBG, Ruth Bader Ginsburg, was famously asked when there would be enough women on the United States Supreme Court. And she answered, when there are 9. Her point was that it had been taken for granted for so long that it was acceptable to have 9 men on the Supreme Court. So why should it not be acceptable to have 9 women? The US model of equality is one in which men and women are treated alike. Of course, I have every sympathy for her point of view, but I do have trouble reconciling it with the arguments that I have been putting forward over many years for increasing the number of women in the judiciary and indeed for increasing diversity in the legal profession more generally. Why should we want more diversity? If justice is blind, why should it matter who the judges are? In September 2000, I gave a lecture suggesting 3 reasons why we should want more women judges: equal opportunities, making a difference, and democratic legitimacy. The first and third were very powerful. They argued for fairness to individual candidates and fairness to society. As to the second, while we should not expect individual judges to make a difference, we could hope that a more reflective judiciary would in fact do so. I quoted Ruth Bader Ginsburg, quoting Judge Alvin Rubin. This would bring a distinctive medley of view influenced by differences in biology, cultural impact, and life experience. Since then, and very much influenced by another great woman judge, Beverly McLachlan, Chief Justice of Canada from 2000 to 2017, I've expanded the reasons into 4. It's worth repeating them. Democratic legitimacy now comes first. Our constitution is founded on the rule of law. The idea that society is governed by laws and not by men, that everyone, those in power as well as those over whom power is exercised, is subject to the law. This means at least three things. First, that the law must be there to serve every member of society, not just one section of it. Women as well as men, people of colour as well as white, disabled as well as abled, poor as well as rich, ill-educated as well as well-educated, and so on and so on. Second, that as the law is there for everyone, everyone must have confidence in it. Everyone must feel that they will get a fair hearing if they come before the courts. Everyone must believe that the courts are their courts, the judges are their judges, not some beings from outer space laying down the law for the rest of us. And third, that our judges and the lawyers who serve their clients in and out of court must be as reflective as possible of the society they serve. This matters along every dimension of diversity, but perhaps most obviously to women, because women make up half of that society. The second reason is the visible embodiment of the values that the law stands for. The guiding values of our law are justice, fairness, and equality. Justice should get us to the right result. Fairness should govern the way we get there. Equality means, at the very least, the value that every human being is entitled to equal respect and to be treated as an end and not a means. Characteristics such as race, caste, noble birth, membership of a political party are seldom, if ever, acceptable grounds for differences in treatment, as Lord Hoffman has put it. Gender was added to that list in the 20th century. One way or another, that notion of equality is reflected in all the modern human rights instruments and in many written constitutions, as you know. It is also reflected in our UK domestic law. Those values of justice, fairness, and equality ought to be visibly embodied, not only in our laws, but also in the lawyers and judges who administer them. The absence of diversity means that they are not. The third reason is equality of opportunity. Women are now joining the legal profession in numbers equal to, if not greater than men in the UK. More women than men are qualifying as solicitors, and roughly equal numbers are qualifying for the bar. We should not be allowing their talents to go to waste, but we are wasting them. There is a noticeable falling out of, or with, self-employed practice as a barrister or a solicitor after 15 to 20 years. The law is not alone in this. Other professions experience the same, but it is particularly noticeable in the law. This is because we tend to think of the law and success in the law solely in terms of self-employed practice, and neither the bar nor the solicitor's profession are well organised to retain members who want a decent balance between work outside and work inside the home. There are tight deadlines imposed in much litigation practice. There is the long hours culture in much commercial practice. Even in academic life, where it is much easier to arrange one's own diary and such a lot of work can be done at home, career expectations and trajectories are structured around the experience of a person without demanding responsibilities outside work. Women, and for that matter men, should feel free to put their family responsibilities before their own professional advancement if they want to. But many want to do both and find it increasingly hard. Such figures as there are suggest that the percentage of barristers who are primary carers for children is far lower than in the economically active working age population generally. It's much better for solicitors. It takes a great deal of support, an understanding partner, good childcare facilities, and an income to finance it, to be able to combine practice and family responsibilities. Increasingly, it is motherhood rather than gender which holds women back. So we ought to find ways to enable all those able young women who go into the law to stay in it or to return to it if they take a break. We ought also to recognise that many of those who leave self-employed practice step sideways into some other kind of legal practice, such as the government legal service, local authorities, regulatory bodies, or in-house counsel in commerce, finance, or industry. where the work is just as challenging, but often more manageable. 60% of in-house counsel of all kinds are women, compared with 49% in solicitors' firms and 38% at the bar. Women who do this should not be regarded as less worthy of judicial appointment. We should be looking for judicial potential wherever it can be found, not just in the traditional pools where those responsible for judicial appointments have fished. These are all good reasons to fight for a more diverse judiciary. But might there be a fourth? Might a more diverse judiciary make a difference to judicial decision-making? Might they even make better decisions? Many senior women lawyers and judges are sceptical about this. We see ourselves as lawyers first and women second. We judges swear a very moving oath to do right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. In most cases, as Mary Jean Coyne of the Supreme Court of Minnesota put it, a wise old woman and her wise old man reach the same conclusions. But of course, legal decision-making is not, or at least not always, neutral or clear-cut. Choices have to be made, and those choices are necessarily influenced by the life experiences and values of the people making them. For all sorts of reasons, women's experience of life is different from men's. As Chief Justice McLachlan put it, we lead women's lives, we have no choice. The same is obviously true of people from ethnic minorities and other less well-represented groups. And the experience of leading those lives should be just as important in shaping the law as is the experience in leading, in the UK, white men's lives. I think that this can matter at first instance, finding facts and exercising discretions, just as much as in the higher courts where law is made. But it obviously matters there. Our law is developed incrementally, building from case to case. As Oliver Wendell Holmes put it, the life of the law has not been logic, it has been experience. So what that experience is matters. Diversity is also good for the bottom line. Research by McKinsey found that inherent diversity, that's gender, race, socioeconomic background, and acquired diversity, experience and skills, led to better business outcomes. Companies with such two-dimensional diversity had 45% more market share. Even without increasing evidence that diverse decision-making bodies make better decisions, I would argue that there is a constitutional case for diversity in the legal profession. As Benjamin Cardozo said many years ago, out of the attrition of diverse minds, there is beaten something which has a constancy and uniformity and average value greater than its component elements. So, unlike RBG, I am not arguing for an all-woman Supreme Court. I am arguing for a more diverse Supreme Court. And to get that, we need a more diverse judiciary and a more diverse legal profession. So what progress have we made in the UK? Well, we have made a good deal of progress with gender diversity in the 20 years since I gave my first lecture. There were then no women law lords, only 2 women in the Court of Appeal and a handful in the High Court. Before I retired last year, we had got up to around a quarter in each of those courts. The position was even better in the lower courts and in the tribunals judiciary, where the proportion of women was roughly equivalent to the proportion in the working population in the relevant age group. The picture from ethnic minorities is not so good. Asian judges now make up 5% of the judiciary, but only 1% are Black and 2% from mixed ethnic backgrounds. Once again, things are much better in the tribunals than in the courts. Nobody is pretending that things are ideal. The Bar Council has just published a report on race at the bar. It shows that people from ethnic minorities find it harder to gain pupillage and face systemic obstacles to building and progressing a sustainable and rewarding career. At all levels, white males earn the highest fee income. Women earn less than men, and Black women earn the least. Barristers from Black, Asian, and other minority ethnic backgrounds can feel hypervisible, bullied, harassed, and marginalised at work, especially at court. Both women and ethnic minorities are seriously underrepresented at QC level. Despite this, more and more people from less well-represented groups are going into the law. Law degrees have become a great deal more accessible. There are now many more universities than there used to be. After the polytechnics became universities in 1992, they were followed by the old teacher training colleges and by completely new institutions, and most of them seem to have a law school. It is easy to see why universities like having law schools. They're comparatively cheap to run, and they can attract well-qualified students. It is less easy to see why so many people, young and not so young, are so keen to study law or to convert to law, having studied something else. When I was a law teacher, my students seemed to have two main reasons for choosing law. The idealists were attracted by the drama of courtroom scenes they saw on television. They dreamed of fighting for justice for some very unattractive people. And this was long before there was the thrill of becoming a glamorous human rights lawyer like Amal Clooney. The pragmatists were moved by the perception, often encouraged by their parents, that the law was a safe and well-paid profession where they could hope to make a good living throughout their working lives. Both the idealists and the pragmatists could get a pretty rude awakening when they actually began to study the law. Then, of course, there is the enormous cost of qualifying for the legal profession. Nadine Dorries, when she was chair of the bar, said that it could cost as much as £127,000 to qualify for the bar. Whether that is so or not, it is undeniably a great deal more expensive than it was when I was young. Studying at university on a state scholarship, with my fees paid, and passing the bar finals with the help of a self-tuition correspondence course bought from the College of Law, which I studied in my attic flat over a long vacation. And there is a very different job market these days. Throughout most of my professional life, both access to justice and access to the legal profession were improving. The Legal Aid and Advice Act 1949 recognised that it was the role of the state not only to provide a system of courts, judges and enforcement which could deliver justice, but also to ensure that everyone had access to it. And although I don't make the mistake of equating access to justice with access to lawyers, it is undoubtedly true that in the common law world, access to lawyers is the best way of securing access to justice. Throughout most of my career, the scope of publicly funded legal services was expanding. The original eligibility rules meant that a large proportion of the population qualified. The remuneration rates for the lawyers were quite generous. The coverage of the scheme kept being expanded. All of this meant that we needed more and more lawyers. So the law courses expanded and the legal professions expanded, and they became more and more diverse as a result. Then, just as the number of people going into the law was growing, the scope of public funding for traditional legal services began to shrink. Public funding was withdrawn from many areas of civil law, including personal injuries and much of family law. The eligibility rules got tougher and tougher, taking most of the population well above them. And the squeeze on what the lawyers were paid became tighter and tighter, making it difficult to make a living, even in the criminal law, where the case for public funding is still accepted. Many of us are seriously worried about the likely impact of all these developments upon the diversity of the legal profession, especially when it comes to socioeconomic background, which is often associated with ethnicity. It's not as if we were doing particularly well before the legal aid changes. In 2013, it was reported that 31% of solicitors in England and Wales went to independent schools. And around the same time, almost 40% of pupil barristers went to fee-paying schools. 35% went to Oxbridge, 64% went to other elite universities, and 81% came from professional backgrounds. And things were worse in the judiciary, with almost 3/4 in the High Court and above going to independent schools, 3/4 going to Oxbridge, and another 1/5 going to elite universities. Things have improved a little since then, but not much. In 2019, it was reported that 21% of lawyers in solicitors' firms went to fee-paying schools. And of those barristers who supplied the information, which is only just under half of them, 34% went to UK fee-paying schools. So we still have a long way to go in socioeconomic diversity, as well as in ethnic diversity, however great our improvements are in gender diversity. So what can be done about all of this? The Bar Council has made a raft of practical recommendations to improve ethnic diversity, many of which would apply just as well to women. But here are just a handful of my own thoughts. First, cut the cost of qualifying for the legal professions. The Inns of Court managed to persuade the Bar Standards Board to accept a new style of bar course, the knowledge component by distance learning and only the skills component face-to-face. Although, of course, COVID has meant that both have had to go online. Solicitors' firms can now offer apprenticeships as an alternative way of qualifying. So persuade many more of them to do so. Secondly, try to persuade the recruiters of the merits of graduates from a much wider range of institutions than Oxbridge and the other elite universities. Get them to come and visit the newer law schools. Explore the possibility of name and institution blind shortlisting. Ban any reliance on unpaid internships, mini pupilages and the like as a recruiting tool, unless they are genuinely open to everybody. Insist on unconscious bias training. It's not perfect, but it certainly helps to challenge and expose one's assumptions. Thirdly, motivate the students to aim to be the best they can, to think outside the box, to be flexible about their futures, to understand how many different paths there are to success in the law, to be resilient when things do not go the way that they want or expect. Give them mentors and role models like them to show them the way. Fourthly, count what you are doing and set targets for how to do it better. And fifthly, finally, remember the second half of diversity and inclusion. Inclusion. Make the workplace a place where people from a wide variety of backgrounds feel safe, feel valued, feel at home. Don't expect them to become one of us. Valuing everyone equally does not mean that everyone should become the same. In fact, quite the reverse. So here's to greater equality and diversity and inclusion in the legal profession and the judiciaries in both our countries. Thank you for listening. Thank you.
Thank you so much, Master Hale. That was great advice indeed, and definitely something that I enjoyed listening to. I'm pleased to say and report that in Malaysia, in our federal court, out of the 14 justices of the federal court, 8 are women. And that would include our Chief Justice, Tunku Maimun, as well as the President of the Court of Appeal. So we're quite good as far as gender equality goes. And talking about diversity, let me introduce the next speaker, Master Malanjum, who, as of last week, is now Tun Richard Malanjum. He's been conferred the highest civil award by our king. I think it'd be something like a life peer, if I'm not mistaken. And Master Malanjum was born in the town of Chuaran on the 13th of October 1952, which was then part of the Crown Colony of North Borneo before, upon independence, became the state of Sabah in Malaysia in 1963. After completing his LLB, Master Malanjum went on to be admitted to the English bar in obviously the Honourable Society of Gray's Inn. And in 1981, or in 1977, he was a solicitor with the Malaysian bar and then was admitted to the Australian Capital Territory bar in 1991. In 1981, Master Malanjum resigned from his post at the Sabah State Attorney General's Chambers and joined a legal firm in Kota Kinabalu, where he became the Sabah Law Association president. He was later appointed as a judicial commissioner in early 1992. In 2006, for the first time since the formation of Malaysia, Tun Malanjum became the first Sabahan elevated as Chief Judge of Sabah and Sarawak, or then, which was what was known as Borneo, and the fourth most senior judicial office in Malaysia. Prior to that, the post was held by a British person, one from Peninsular Malaysia or Malaya, and several Sarawakians, so he's actually the first Sabahan. And he was sworn in as the 9th Chief Justice of Malaysia, the highest judicial officer in Malaysia, on the 11th of July 2018, becoming the first person from the Borneo states of Malaysia to ascend to the office. And these are a lot of firsts. So talking about diversity, I think Tun or Master Malanjum ticks all the boxes insofar as diversity goes. And without much ado, let me invite Master Malanjum to present his talk. Master Malanjum.
Thank you, Farik. And good morning, Lady Hale, Master Malek, and Master Desmond, and Yang Arif, Justice Su, and all the others. Yeah, it is already evening in Sabah, and I'm sorry my line might be a bit bad because we are in the remote place of Malaysia. Rather, we have not got a good line. And should I break up, please forgive me. I'm trying my very best to minimize the usage of it, and hopefully it'll be good. Anyway, thank you for inviting me to this webinar. I know that the Grace Alumni for Malaysian chapter has been around for quite a while I was still on the bench. And I must confess that I've only been trying to resist being a member for fear that the other Inns of Court members may say that I'm biased when it comes to hearing of cases. So I was a bit sensitive to that. And I've been postponing it, but upon my retirement, quickly I said, yes, time has come. Because I had a very fond memory of Grace Inn, and particularly the food. First, it's cheap, and for students, yeah, and good at the same time. And I used to invite fellows from Lincoln's Inn to join me, and they always say, Grace Inn, good food. So can you imagine that? And the other thing that I fondly remember of Grace Inn is the library. Fantastic library, and I will normally sit there for the whole day without feeling anything, and very quiet and very conducive to study. So that's so much for a fond memory of Grace Inn. And whenever I visit London, I used to drop in, and the staff there has been always been very, very nice. So that's it. So having heard Lady Hale, Master Hale for talk, I think I'm a bit of a midget here, but never mind. I'll present my side of the story from the from Malaysian side. Yeah. Firstly, just to follow up with what Farik said. Indeed, yes, we have good diversity of ladies, the gender equality in Malaysia. May not be so much from the indigenous aspect, because I can say that I'm the first indigenous or the native of being recruited into the judiciary after a long period of time. And it has been quite unnerving to begin with, yeah, because unfortunately, it's always the case when you are the minority, and sometimes you find yourself out of place. So you need a strong determination to say, well, I do eat rice as well, so do they, and therefore there shouldn't be any problem. So that is it, and that's how it is. The other thing that I've realized the problem over here, because I do teach in the universities now, law faculty, is this. A lot of, sometimes I get these two questions coming from the student. One is this, especially from the ladies, yeah? When is the right time to get married? And I always find that very difficult to answer. And I always tell them, it's up to you, but do not get married unless you are ready. And they always say that, and I ask why? Because I know, well, if I get married, I'll be taking care of the children. And how do I then practice? So in a way, Lady Hale, Master Hale is quite right in that, because normally the shoulders, the caring of the kids always fall on the shoulders of the wives. So that's the question. And of course, the other thing that they used to mention to me is this, yeah. And they said that, especially those coming from a lower income group, they always said that they find it very difficult to find places to chamber. Because usually the firm will ask their background. And when they come from where the family, where the father is just a laborer, ordinary laborers, it seems that they quite a number get cold shoulders from especially from the big firms. So it's really very sad. So I used to tell them, never mind, I went through the same problem. I said, when I was in my younger days. So these are things that we might have to address, and I'm sure the Malaysian chapter can look into this. Yeah, that'd be great if we can do. Anyway, I will not digress too much. I have a slide actually, but I don't know whether I can get it here. Let me try to get it if I can. If it is not there, and then I'll just stop, I think. Yeah, most likely it's not here. Yeah. So this alumni will be, of course, great help, yeah, because it will create more of sense of belonging, considering that the distance between us and London, and with the establishment of alumni, it helps a lot. And indeed, my talk this evening or this morning over there is not so much to do a knowledge sharing on the law, but rather to highlight the problems that I see it. And I'm sorry, Justice Su, but you may have to be extra work after what I've said there, because I'm going to suggest a few things which the chapter may have to do something. And of course, there are two things here. Yeah, one is, of course, on the law, and the other side, of course, is a little bit of administration. Firstly, I tried to push for membership of our alumni or chapter in Malaysia, especially the young ones. But I always get this question, yeah, what do we get out of joining the alumni? Sounds a bit selfish on their part, but kids are kids, I think, or young guys always ask the questions. And the other question I said is, how can I help the alumni, or how can alumni be of use to me or to the society? Which revolve the same question, what do I get out of it? So I was thinking about it, and possibly one of the attraction that we can maybe give is this, that if only that the parent body or the London Grace Inn, whenever there's a webinar, especially on law, whether the chapter can organize it and we can join in. And that would be a very good knowledge sharing for us over here, because sometimes we do get quite slow in our information on the development of the laws in London, even though it's the internet age. Yeah? And the other thing, of course, is I don't know whether the Grace Inn library is online. So if it's online, it would be very good as well, because then we can subscribe to it, and then we can then get access to the good books from the library. So that may be another selling point for these youngsters, if we can consider that. And of course, newsletters as well, on a little history or news about the legal profession overall or in the Commonwealth. So there you are, Justice Su. Sorry about it, but these are small suggestions. And because you know why, being now retired, I'm also doing farming, and I do sell vegetables. So I realized that you have to be a salesman to be effective. And there you are. So that's it. These two are the points that I would like to highlight first. Yeah. Now, coming now to the topic that which I want to say, and I put it as a topic as the use of the English common law in Malaysia, and I put a Vadis here, because the reason why I said it is this. This has come up as a current issue in Malaysia. How much can, or how far can we continue using or adopting the English common law? And of course, a bit of a history. The English common law, of course, was introduced to this part of the world when it was under the colony, yeah, as a colonies of Britain. But before that, the system that was used or practiced by Malaya was, of course, very much on the Islamic law. I think more of Islamic law, and the Boni states, a lot of us were on the indigenous law, a little bit of Mohammedan law and so forth, but more on the indigenous law, tribal law. And of course, with the advent of English law, we have moved then to the use of the English legal system. Now, how did the English system come in about? So basically, of course, they were being colonial territories. The system came in, the judicial system, as early as 1807, if I recall properly. And at the same time, legislation came into play, and there is one particular legislation of which has been the door into which through which the English common law has been brought in, and that is the Civil Law Act. And there are two sections there, Section 3 and Section 5. And of late, the existence of these two sections has been quite controversial. Some have been saying that it should be abolished, and some say it should be improved or amended, and so forth. So these are points that of which I think the alumni or the chapter can really look into it. And unfortunately, at the same time, Section 3, for instance, of the Civil Law Act Malaysia, there's a cut-off point in the application and the adoption of the English common law. For Sabah, it was in 1956, I think. No, it was an Act of 56. There is a provision. I can't really remember when was it. Let me get it. Let me get when is it? Oh yeah. I think it's about. I can't get. Hold on. I just go into my. Just get into my. Give me a minute. Okay. All right. It was, I think, in right. Hold on. Give me a minute. All right. Right. In Peninsula, I think it was 1956, and in Sabah, 1951. That was a cut-off point, technically speaking. And Sarawak was in 1949. So, but the funny thing is that up to today, the English common law principles are still flowing into Malaysia. So there is a big question now of what happened to Section 3, or what happened to the cut-off point. These are things that having a little bit of impact on our development of our law. And the other thing, of course, is this, that a lot of codification done of the English common law principles, and then being passed as legislation or statute in Malaysia. For instance, the Contracts Act 1950, the Evidence Act of 1950 as well, the Penal Code, and Criminal Procedure Code, as well as the Sales of Good Act. And ours is way in 1957. And as you may aware that most of these codification of English principles were done at the point when it was legislated, what was then the law of the English law at that time. So the challenge actually is this. How are you going to interpret those provisions of those acts with the new development of the English common law in UK. Can you therefore apply the new or the latest English common law even interpreting the sections of those codified statutes? Some says it can be done, but there is actually a problem there because that was an old principle, and are we therefore entitled, the judges, entitled to interpret those sections taking into account the development of the English common law? Otherwise, the judges might be accused of judicial legislation. So that is one point that which has been going on among among the academicians. And but of course, the late His Majesty the Sultan Azlan Shah says this, that the minute you accept or you apply the English common law, it turns into a Malaysian common law. And from there onward, the courts are entitled to evolve it or to vary it or to modify it. That is the approach, one approach that His Majesty suggested, and that was way back in the 1980s. And the other thing, of course, recently there was a decision of the federal court in Malaysia to say this, that the common law of England, English common law, once it's adopted in Malaysia, the Malaysian court is expected to follow that development and to apply or possibly to adopt those development. I don't know whether then you are going against Section 3 of the Civil Law Act. So that is also another question that, another issues that might be of interest in a kind of a seminar or a webinar, and alumni can, I think, can organize, because these are interesting point of law which we have always have a problem on this. And even in another case by the Court of Appeal, where they actually say that this, and if I may read, our courts should therefore adopt an approach that is best suited to our own needs and values, paying such respect as are due to the approach adopted by the courts of countries whose values upon particular subject may be at variance with our own. So you can see that there seems to be a push on it. But I ask a question, actually. What are the elements of the Malaysian common law? What are things that we need to consider to say that, well, this is the Malaysian common law? Some says, there are some articles written by academics to say that, well, the only way to do it is you abolish the Civil Law Act and then use the Islamic principle as the Malaysian common law. Unfortunately, for Malaysia, it's a multiracial, multicultural country. So it might not be easily accepted by a section, a good section of the population. Because if that is the case, and if that is being done, and then the indigenous in Sabah can then say, you must take into account my culture, my customs. And one of the customs in Sabah, of which I am bound by it actually, being the native, is this, that the wives, the wives are obliged to take care of the husband regardless of the behavior of the husband. And if the wives refuse, they can be penalized under the native laws. So you can see, I don't know whether it's too advanced for the time, but that has been the law of our tribes ever since. Now, will that be accepted as the common law of Malaysia? These are things that is quite disturbing. Whereas at the moment now, common law, if we were to, when we take as guide the English common law, and we're only interested in justice and fairness, and I think that should be quite sufficient for everybody's need. That issue again I think it will be quite sensitive if there is a debate on this, and everybody will be asking what common law, yeah, and that's interesting. So I would say, and the other thing that is a bit disturbing of late is this, yeah, we have been following the development of ouster clause in England, in UK. And we have read the Miller's case, Master Hale, and of course the previously international case, and as well as, of course, Ismail and all that we applied. The question is this, and that especially on access to justice. We have amended our constitution since 1983, I think, whereby the constitution said this, that the judicial powers of the court, the judicial powers of the court is subject to federal laws. And if one is to be very positivist about the approach, one then can say, look, as long as Parliament does not legislate a jurisdiction to the court has no jurisdiction to hear a case or whatever. And with that, the ouster clause provision has been used to say that, look, Parliament has ousted a particular jurisdiction for the court, and therefore, so be it. The court has no jurisdiction. And but some judges, with all due respect, take that view, a very literal approach to that. But I, for one, when I was on the bench, I said this: common law includes access to justice, separation of powers. Yeah, and so, and therefore, if common law has been adopted by the Malaysian court, English common law, which include access to justice, it survives. And regardless of what Parliament may say, whatever the section, Article 1 of the Federal Constitution, regardless what it says, the court should have still the jurisdiction to oversee or to question the legality of those statutes. So this has been quite a sensitive issue, especially in the recent times. And there are actually two schools of thoughts now. One says that there should be a liberal approach to this. So whatever Parliament may say to legislate to exclude jurisdiction of the court says, look, we still have the right to look into it, especially when there is a question of law involved. Very much, I think, similar to the Miller's case, regardless. And but some says no. The constitution is very clear. The judiciary can only act if there's a federal law. It's only entitled to act, or is only empowered if there's a federal law to the particular subject. When if there's been an exclusion clause and an ouster clause, that has to be respected and must be followed. I take it this year that if therefore the Parliament pass any law as they like, even to the extent of being unjust, is the court or the judiciary stand by idly and just look quietly, fold their arms and look at what's happening? My view is that it should not be, because there is always the inherent power of the court to question the legality of those legislations, regardless of whether it's ouster clause or not. And this, I think, that has been, as I say, the journey of this debate has been quite a checkered direction, in a way that it's neither here or there. One section will say this, other fellows, other group will say that, and it's not healthy. It's really not healthy, because by doing that, three things can happen. One is that there's undermining the doctrine of separation of powers, which I think is dangerous. Two, there is the undermining the rule of law, and it may turn out to be a rule by law. And we all know that rule by law will be a dictatorship. That's not right. Yeah. And three, of course, is that why should the court be inferior or subservient to the legislature? Just because of that. So there has been a talk to amend that article 1 of the Federal Constitution, but so far it's all talk, and so far it has not been much of a result. So this is one point, I think that hopefully alumni, our Malaysian chapter can organize a seminar, and we can invite Master Hale to give us a talk, and possibly many will listen to that. We have a problem on this. Honestly, it is a burning issue, if I may say. And I must say, I'm very worried about it, because if we give in to the positivists and say that, yes, whatever Parliament say, unless you are being given the jurisdiction, then only you have. We are heading for no more a rule of law, but a rule by law. And the question of access to justice may be in jeopardy. So that is that. The second point that I wish to touch is this. I was saying about the Contracts Act and all this codification of the law. So there is a cut-off point in the absorption of the English law. Yet some of our cases have been adopting recent judgments of the English courts, especially the Supreme Court. I, for one, when I was on the bench, yes, I applied Cavendish in a penalty case, case. So there may be a question to say, Section 3 of the Civil Law Act stops you from doing so because there's a cut-off point. But I think my view is this: it's not so much of taking those principles by the English Supreme Court as binding, but the judge should consider them as a guiding light to do justice, to attain justice, the reasoning. Because I have seen other judges not only considering the judgment from UK, but as well as from Australia, New Zealand, and other Commonwealth countries. So maybe that is one way to approach that. No doubt, maybe the section of those codified statutes are, I would say, maybe fossilized in those days, but I think it can be melted through that argument, that it is not so much a binding, taking it as a binding precedent, but being a guideline, a guiding light, so that we can attain justice. So that is another interesting approach that I think hopefully it can be discussed in a webinar or in a seminar, and hopefully the chapter, the Alumni chapter, the Malaysian chapter can organize. That would be an interesting point. I know it will going to be quite controversial, but why not? For instance, the question of fundamental breach in a contract. Are we still tied to the colours principle, or now we are the Suzy Atlantic and photo production? So recent cases, even by the Federal Court, adopted those, and as if they are binding principles, but so far nobody has complained, I think, with that. But if it is being stated as being persuasive, I think it makes no harm. And that's what I have done in a cubic case. I say it's persuasive and it should be a guiding good principle, but not as binding. So that may be the way to overcome the constraint of Section 3 of the Contracts of the Civil Law Act. So with that, Master Hale and Master Malek and Desmond, Master Desmond, and Justice Su, Farik, and everybody listening, I've said my piece, but I look forward to the Malaysian chapter to organize one, and at that time I'll be an eager listener, because these are points that really quite disturbing, I think, even to many judges today. I may be wrong, but I feel that that's how it is. All right. So thank you for listening. Thank you very much. Thank you.
Thank you, Master Malanjum. Thank you very much. Very insightful into how the judiciary thinks. I mean, personally, I think that we definitely need the judges to keep a check on the politicians. So separation of powers is still very, very important. So whatever ouster clauses Parliament may try and put in, I think we still need the judges to act on their conscience. And they have. I think there are a few landmark cases. On precedent, I guess we still have to look towards the UK for precedent, especially with the COVID-19 cases. As an insurance practitioner, I've had to look at the FCA against Arch, which is the leading case on COVID-19 on interpretation of insurance clauses in respect of COVID-19 cases. So, as you said, maybe we can't say that it's binding precedent, but under Section 3, very, very persuasive because there's nowhere else to look. Can I, before I invite Justice Su for winding up, I don't know whether there are any questions maybe from any of the Honourable Masters to either Master Hale or Master Malanjum. I notice Justice Mary Lim has thanked Master Brown and said and sort of commented that the advocacy training continues strong in Malaysia and the good seeds planted have borne fruit. And they're now part of the international faculty. And I think that's very true. With the help of obviously the QCs and the justices that came over for advocacy training. I'm one of the products of that. We have to thank you all for coming all the way to Malaysia and improving our advocacy skills. And I think that's something that maybe Gray's Inn can continue with us as well, with I would say the members and barristers of Gray's Inn in Malaysia to sort of sharpen our advocacy skills so that we keep the best of traditions of advocacy.
Well,
there's a very long question. I see.
Well, advocacy training is still taking place remotely.
Yes.
The Inns of Court School of Advocacy have had successful training remotely in the United States. So if there is anything that we can do either for the Gray's Inn alumni or for the alumni of other inns in relation to training, you have only to ask. If you don't ask, you won't get it. We're not going to inflict advocacy training on you willy-nilly, but if you ask, I assure you, you will get a positive and heartening response. Can I just say a couple of other things about socio-economic disadvantage, which has been the subject of mention by both Master Hale and Master Malanjum. Two things. Firstly, as Master Hale says, it is terribly important that selection be blind to both institution and, of course, names. Names are so often a giveaway. In the Inn's own new bar course, for which I'm ultimately responsible, I say ultimately responsible because others do all the work, we have an entirely blind selection system, and it has proved without sacrificing quality that a relatively small proportion, only 26% of the total, have been to Oxbridge. So that's a heartening figure for those who advocate the cause of other tertiary institutions. Of course, you, Tunku, Farik, have been to both Bristol and Cambridge, so I'm not quite sure which group you'd fall into. So that's one thing. The other thing is that I've been in contact with Malaysia for so long. I now have a lever arch file of documents. And one thing that I did discover when digging it out this morning is that one of the objectives of the Constitution of the Malaysian chapter of the Inn is to establish an educational fund for deserving student members to become barristers of the Inn. I don't know whether that is still a live objective. I'm not sure whether the aims and objectives of the chapter have been looked at since the date of the Constitution in 2008. But were such a fund to be set up, then it would seek to meet some socio-economic disadvantage and would be warmly supported by us at the Inn. And that's really me for the time being. I've reached my sell-by date. My 4 years as Master in Charge of International Relations are now at an end. And who could be better to take over other than Ali Malek on the 1st of January?
Congratulations, Master Malek. There is one question to ask Master Mallanjum. I'm not sure whether you can see the question, Master Malanjum, if you click on the Q&A, but I will just press say it for you. It's in respect of ICED, which is the International Convention of Elimination of Racial Discrimination. The person has asked, are there any legal reasons that prohibits Malaysia from adopting ICED? Or and then the person goes on to ask whether it's, in your view, is it incompatible with any part of the constitution, etc. So maybe you'd like to take that question. I pressed it, but a bit controversial, but I leave it to you, Master Malanjum, to answer that.
Thank you. Well, that was being pushed by the former government of Malaysia, I think last year or so, on the journey in ICED, but it has become very sensitive, politicalized, and some have even hijacked the whole concept of that. And as a result, nothing went through. I'm sure the Aegis chambers must have studied it well before the government proposed it for signature. And in terms therefore of being constitutional, unconstitutional, I think that has been studied. Otherwise, the previous government would not have proposed it to be adopted. So at the moment now, that is in limbo, and no politician there to touch it at the moment, in view of the fact that he has been given poison ivy, I think, if you may use the phrase. They've covered with full of poisons, nobody dare to come nearby. So sad to say, but that's where we are at the moment. That is the position. But before that, I just want to ask a question. I just want to ask a question from Master Brown. And that's it. Is there such thing as honorary members of Grace Inn? Because we have a lot of local law graduates here who are actually very keen to be a member of the Inns of Court in UK, you know. But I told them you have to study and be admitted to that inn in order to be a member. So is there such thing as associate member? Because if there is, I think many will join to be associated with the inns, because we don't have an Inns of Court system in Malaysia. I wonder what is it like, whether that is permissible or not.
Well, we don't have associate members, honorary associate members. We, of course, have honorary benches, and we're delighted that you should be one of them. The proposal that you make has been raised before in relation to both Gray's Inn and the other inns. And although it's not being pursued, I mean, one possible way of dealing with it would be for you in Malaysia to do something like has been done in the United States, which is to set up your own Inns of Court with reference to the English and Welsh parentage. And that would receive, I'm sure, the support of all the inns. But I think the proposal that you make is one which has got to be adopted, not just by one inn, but by all of them. And of course, having associate members, we would need to be able to know that they subscribe to certain common values. I'm sure that is the case with those who'd want to join from Malaysia, but it does require a little thought. And so far, that thought has not been given to the prospect, but personally, I would welcome it.
I think there is a Malaysian Inns of Court that has been formed, although I won't make much comment on it, because I think we at Grace are still very loyal to our Alumni Association, so we don't see reason to join the Malaysian Inns of Court. Master Malanjum, I have one question, just one question that I'll take from the floor that they've given, and I think it's quite up your street. The question is, Master Malanjum, do you agree that the development of native customary laws in Malaysia have regressed? I'll give you that one, I think, and I think we're running out of time because I see Samantha sort of peeking in through to remind me that time is over. So we'll take that as a last question.
I just wanted to tell you that there are actually more questions in the Q&A box
can see.
at the bottom.
But I saw 10 minutes. Is there 10 minutes?
Not in the chat, but in the Q&A itself, a different box.
Okay.
If you look at the bottom of your screen, there is a Q&A box. I just wanted to, yes, so there are some questions there.
All right, so there's, so we'll take the one in the chat first, Master Malanjum. Do you agree that the development of native customary laws in Malaysia have regressed?
You're being very kind when you say it's regressed. I would say it's about to be killed. And simply is this, that I've been advocating the system to be upgraded as if it's similar to the civil courts and as well as the Sharia court. And the main one is the selections of judges. Presently, the judges of the native courts are selected by the politicians. And they have no tenure of office. They can be fired anytime. And yet, they play a very important role in the daily lives of those in the rural areas. I've come across indigenous, they only know of the native courts. They have never heard about the civil court. And yet, that system seems to be given a backseat. So I've been pushing for it, but politicians are politicians. I don't know how to win them. I have to learn how to be a missionary, I think, before I can convince them to my side. But they're very difficult because they want power. And they use sometimes these native chief, we call them, as political instruments. And that's not fair. And that's the reason why, if you ask me, regress may be more than regress. My biggest fear is that soon it may disappear. And if it disappears, it's a death of a culture. And if there's a death of a culture, the death of the tribe. And there will be no more indigenous, I think, in the end. We may end up being just similar to whatever the tribes now without homes and so forth. So I've been very particular about this. It identifies us. Our culture is the identifying point for us to feel that we are the indigenous. So whenever it's being touched, I'm sorry, Master Hale, but I'm quite sensitive about this. I always get very emotional sometimes when it comes to that, because I've seen it. In the olden days, it used to be during the good times, even during the British, it used to get a lot of respect. But it is now, when we're supposed to be independent, that is not being given much treatment. A lot of washy here and there, but substantively, there's none. So, and for instance as well, the Orang Asli, the Aboriginal of West Malaysia, they don't have a system at all. They don't have, even though within themselves they have the indigenous laws, but it has not been regulated, it has not been systemized in a way, it has not been recognized. So there you have a big chunk of a population of the country where they only know of the civil court, they are only subject to the civil court and not to their own way of life. So that's it. That is the position now. I'm quite sad about it, but a lot of political will, I think, sympathetic political will required to change the direction. Thank you.
We have to leave it to you, Master Malanjum, as a former Chief Justice, to sort of promote native rights and all that, like the First Nations, I think, in Canada and also in the US is becoming a very live and topic. Master Hale, there is a question for you, so I'm not letting you go without putting this question. Someone, I believe from Malaysia, Nurul Huda, has asked, with the population of females increasing more than males, would diversity still be an issue when the female could have easily taken the male's role or office, as happens in other parts of the world. The issue is whether there's willingness to recognize this. So can I leave you to answer that question, Master Hale?
Well, I'm afraid that diversity doesn't spring from just numbers, does it? There may be more women than men, only a few more, not very many more, but that doesn't translate necessarily into the legal profession or into the judiciary. It requires all the other things that we were talking about earlier. Could I just say, I noticed another question in the Q&A. I think the first question in the Q&A.
Let me go back.
Yeah.
From Jacob.
It's the one where somebody said, but what about merit? Do we increase diversity at the expense of merit? Which is a very frequently asked question.
Yes.
And to which my answer is no, of course we don't increase diversity at the expense of merit. We need to appoint meritorious people from wherever their background, ethnicity, gender, and the like. But I do sometimes question how we define merit, because it is very easy for the people who have traditionally been seen as meritorious to think that merit resides in other people like them. And that isn't necessarily the case. So we have to unpack the concept of merit, work out what it means, and work out how to judge it. But certainly we don't want diversity at the expense of merit.
Definitely something to agree upon, especially in Malaysia, where so many different races. We are really a hot, melting pot cultures and people, all sorts of people, and it's very difficult to balance between the races. And it's not necessarily that the minorities are being helped either. Sometimes, there's a lot of regression, I think, and Master Malanjum agrees with that. Can I take any more questions, Samantha, or is the time quite tight?
I think we can take
a few more, okay. Someone has asked, Master Hale and Master Malanjum, what's your advice to members of the bar who are looking to become a judge in the future? So I think, I think that's rather an interesting question. So maybe some advice is
if that's a question from Malaysia, I think that Master Malanjum should be.
It says anonymous attendee, so it doesn't say.
It could be from the UK.
It could be from the UK.
Yes. Let's have an objective view, Master Hale.
Well, in the UK, we have a Judicial Appointments Commission, which recommends all the judicial appointments, and the role of the government is very limited. And so the advice would be to go on the website of the Judicial Appointments Commission, find out what the various opportunities are, find out what the criteria are for appointment to those various opportunities, ask yourself whether you might meet enough of those criteria to be considered, and then think about joining one of the mentoring schemes that enables you to be helped to understand what's involved. So I think there's a fairly straightforward answer when it comes to the UK.
Master Malanjum, any comments on the Malaysian situation? We also have a Judicial Appointment Committee as well, JAC.
Yeah,
I think
we have the JAC Judicial Appointment Commission, and of course, same as UK, is very much on advisory as well. But the law here is that the Prime Minister still have a lot of say in the appointment of judges. But then I just move on to how do you qualify, or how do you become a candidate of being a judge? I think the first element or the first requirement is that you must be hardworking as a lawyer or as a public servant and so forth. Yeah, you must work hard and you must show your talent, I think, and that is where your merits will be seen. And as Master Hale says, it's through merit. So otherwise, there's no point. There's no such as entitlement. Just because you belong to a certain group, particular race, therefore you just wait for your time to come. I don't think that should be in the mind of those who are potentially interested to be a judge. He or she should work hard, show his merit, especially in terms of litigations, and then you'll be noticed and you'll be interviewed. And if you can answer those, satisfy the interviewer, then you may get it. So to me, that's how it should be. If there is if it is on the basis of entitlement, because I belong to a certain group, therefore I should get it, forget it. I think it'd be very sad for the country if that is in the mind. Thank you.
Question for you, Master Hale, is actually from my fellow Bristolian, Miss Go, Siulin Go. She's asked whether you would be able to share with us your sources of inspiration in your professional and personal life. She's also interested to know which of your judgments that you think you're proudest of. And that's quite a good question. So I'll pose that to you.
Well, I think the source of inspiration for most of us, it starts probably in the home with our parents. My parents were both teachers and they were very keen on education. They believed that their 3 daughters should be educated. Then, of course, there were teachers at school who inspired one to enjoy particular subjects, teachers at university who inspired one to think big about what the future might hold. And throughout life, you meet inspiring people who encourage you, act as role models for you. And I mean, in my case, obviously, there were some amazing women at the bar and in the judiciary who showed that it could be done, and I wanted to be like them. So that's where that comes from. I think as far as which judgments is one most proud of, this is a really difficult question, but I probably have to say that the unanimous judgment of the Supreme Court in the prorogation case is the one that obviously will go down in history as the most important decision constitutionally and in other ways during my time as president of the Supreme Court and even on the highest court in the land. So I've probably got to go for that one, although I have a few other little ones up my sleeve, which are not so famous.
I think that's the famous one where you became, I mean, the comment Spider Woman, you're wearing your spider brooch, I think, when you delivered that judgment of the court.
Yes.
I've got, this question is from a Malaysian who's in the UK, probably he or she says she hopes to join the criminal bar in the UK, and the matter of the matter of his or her nationality still an issue when considering whether to seek a career in the UK or Malaysia. And basically this person is asking probably the views of the masters in the UK, whether how difficult it is for Malaysian to seek a career in the criminal bar in the UK.
I think it would be a good idea to hand that question over to Master Treasurer,
yes,
whose ear will be closer to the ground than mine in that respect.
To be honest, I don't know the answer. I reached across to Master Desmond Brown.
I knew it would end up with me in the end. I assume that there are no problems with immigration. The question raises the issue of whether there would be any form of discrimination in seeking pupillage or a tenancy in a set of criminal chambers at the English or Welsh bar. And I would strongly hope and indeed believe that that wouldn't arise provided you satisfied the merit expected. So nationality shouldn't be an issue. The problem, of course, is establishing yourself here. You've just completed the BTC. You've seen something of the way sets of chambers work by attending many pupilages. I would encourage you to apply. I think that now more than ever, what needs to be done is to not allow yourself to be disheartened by all the obstacles along the way. And we certainly need at the publicly funded criminal bar the widest possible variety. And there is, especially after COVID, a shortage of practitioners. You'll be told all sorts of dismal things about the future of life at the criminal bar, and you certainly won't make a fortune, but it is something that we badly need able men and women to join.
Thank you, Master Brown. I've been told this is the last question. That was the last question. So I now invite Justice Su to make his closing remarks and draw the event to a finish. And thank you very much to all, Master Hale, Master Malanjum, and Master Malek and Brown for all the answers that you've helpfully provided. Thank you very much.
Thank you.
Justice Su, your mic is off. You need to switch it on. Your mic is off, Justice Su.
Yes. Thank you very much, Tunku Farik. Salam sejahtera, Yang Amat Arif, Ketua Hakim Negara, Presiden Mahkamah Rayuan, Hakim Besar Malaya dan Hakim Besar Sabah dan Sarawak. Yang Arif, Hakim Mahkamah Persekutuan, Hakim Mahkamah Rayuan, Hakim Mahkamah Tinggi, dan Pesuruhjaya Mahkamah Tinggi. Penaung-penaung, patrons of Grace Inn Alumni di Malaysia, Tan Sri Siti Noma Yaakob dan Tun Richard Malanjum. Wakil daripada Lincoln's Inn Alumni, Datuk Ma Weng Kwai, Justice Datuk Faiza, President of the Inner Temple Alumni, Wakil daripada the Middle Temple Alumni. Peguam bela dan peguam cara serta peserta-peserta yang dihormati. Dengan rendah diri, saya akan meneruskan dalam bahasa Inggeris. A very good morning to the participants from the United Kingdom and a very good evening to those from Malaysia. I also wish a good day to each and every participant who come from jurisdictions other than UK and Malaysia. On behalf of the Malaysian chapter of the Honourable Society of Grace Inn, it gives me great pleasure to thank Master Lady Hale and Master Tun Richard Malanjum for agreeing at short notice to speak at what I hope will only be the first of many cross-border collaborative engagements to come. I'm indeed humbled to be given the singular honor and privilege of sharing the same space with these eminent and illustrious jurists. A heartfelt thanks goes to Master Treasurer Ali Malek QC for the informative talk on Grace Inn UK, and our able moderator, Yang Mulia Tunku Farik bin Tunku Ismail, who is the Vice President of the Alumni. The Alumni and I thank Master Desmond Brown, who played a pivotal role in getting this event going and in persuading Master Lady Hale to speak on this occasion, as well as marshalling the resources of Grace Inn London to support it. A big thank you goes to the two Sams, Samantha Su, a committee member of the Alumni, and Sam Hutchinson, the Chief of Staff of the Inn, who both worked very hard behind the scenes to see to the promotion and success of this event. A mention has to go to our Alumni Committee member, Datuk Roger Tan, who spearheaded the promotion of the event in Malaysia, together with the helpful assistance of Alumni Committee members, including Tayanadan Bhaskaran and our Honorary Secretary Samrit Singh. Thanks also go to all our committee members who are all Malaysians, but coming from a diverse range of ethnicity. On the topic of diversity and inclusion, if I may say a few words on it. I had occasion to hand down my grounds of judgment a couple of weeks ago on 2nd November 2021 for a decision I had pronounced on 26 October 2021. I had allowed bail to 8 individuals who were all men accused of committing security offences under our Security Offences Special Measures Act 2012, also known as SOSMA. Now, under this act, children, persons who are infirm, and women are amenable to bail. There is, however, no provision for bail for men. On the ground, the Article 8 of our Federal Constitution forbids non-gender discrimination, forbids gender discrimination in any law. I had construed women to include men, so that the law in this act will be read harmoniously with the Federal Constitution. I then proceeded to grant bail, subject to several conditions, to these 8 men. Our Honourable Public Prosecutor was not impressed and has expressed his dissatisfaction by filing 8 separate notices of appeal. Needless to say, I stand corrected by the Honourable Court of Appeal, and if it is taken further by our apex court to the Honourable Federal Court. Whilst there, I believe the vexed issue that Master Tun Malanjum alluded to earlier, the doctrine of separation of powers involving Article 121 of our Federal Constitution will probably be addressed yet again. On that note, I return to thank each and every one of you for participating from your respective parts of the world. On behalf of the Malaysian alumni, I once again thank the organizers for all the efforts in putting this event together and making it a success. And we sincerely hope that the intensity of our collaboration will grow further henceforth, bearing in mind the challenge thrown by Master Tun Malanjum to make it very much worthwhile for members to join the Grayson alumni. On Master Hale, speaking about the Constitution, I'm sure you will find that she has actually given a very enlightening paper during the lecture, during the Sultan Daslan Shah lecture, and it is available online. The topic is the Supreme Court, Guardian of the Constitution. With that, I bring this webinar to an end. Goodbye and selamat tinggal.